So let us look at the steps that are important, key to prepare for disciplinary hearing. Number one, recording or reporting the incident which has been observed. Keep the record of what has been reported, be it in writing, verbally, so the record needs to be available. Number two, conduct the investigation. We've spoken about investigation a bit, but it's an important part of the preparation because it allows the employer to seek detailed information and obtain certain information that will substantiate whether this can be served as a charge, serious offense, and or warranting a disciplinary to take place or not. Number three, preparation of the notice of the hearing. This is a document which is very important. You cannot just simply send an email by saying you are supposed to or someone to come to a hearing on this date. It needs to be clear. One, it has to have the indication of a clear date. When is the hearing to take place, the time, the place of hearing, and the charges that have been laid against the accused employee. Those need to be clearly stipulated on the hearing document. Number four, the hearing must be served to an employee, and the employee should confirm the receiving of the hearing, preferably in writing. At the bottom of the hearing notice, there should be an area where the employee signed to say, I acknowledge receiving this hearing on a particular date. The employee can keep the hearing notice copy, and the copy can also be kept. Another copy can also be kept with the person who served it, in this particular case, the employer. Obviously, as part of what needs to be included in the hearing, need to be the right of the employee. The employee's rights need to be included in the hearing, so that the employee will be informed as to what rights does he have in undertaking in a particular hearing. So one of the things that need to be clearly afforded to the employee is the time to prepare for a hearing. Different companies does have different time frames, but we normally recommend not less than 3 working days so that an employee can be able to go through the charges. At first, he might be shocked because he might be getting this for the first time, unexpectedly so. Then he needs to be able to go through thoroughly to be able to understand what is in. And we do know that most employees do not tend to ask as to what does this mean. They just assume that they know what is included, and therefore they will think they will do their own preparation. Once the service of notice has been done, or notice of hearing has been done, the appointment of the presiding officer by the employer. And this becomes an important part. The presiding officer need not to be familiar with the content of the case, not at all. He or she can be able to be informed of the details of the case during the hearing itself. But the other person who also needs to be appointed is the case initiator. This is a person who would directly be responsible for filing the evidence against the employee and present the case of the employer against the employee. Now, it is important to know that the presiding officer has to be appointed by the employer, and this can be someone within the organization or can be someone outside the organization. One of the key important steps before the hearing itself does take place is that an employer who has been given certain rights, including the right of having a representative, can and should, if he sees fit, appoint a representative who can also assist him in preparing for the case thoroughly from beginning until the date of the hearing itself. Now, when a hearing does sit, then that's where everything comes to fruition. The presiding officer has been appointed, and the hearing has to commence and start. But if we were to look at the presiding officer as an important stakeholder or a role player in a particular hearing, what kind of roles this person need to be performing? Or perhaps should we also ask the question, what kind of qualification or knowledge he should be possessing? This should be someone who is obviously knowledgeable about the labor relations or labor law, as it were. This should be someone who should be able to familiarize himself easily with the procedure of the company, someone who is informed about the labor legislative framework, who should be able to deal with the matters, as it were. In some organizations, companies will choose people or will appoint people who are not as knowledgeable. In most cases, you find that a lot of issues do emerge whilst a person is finding his own feet. So we normally highly recommend that a person who's appointed as a presiding officer is a person who's an expert in labor law, who's experienced and has got skills to facilitate, to chair a particular hearing, especially if a type of a hearing is rather complex. So, but the company can decide as to who can be a presiding officer. We've spoken about the hearing notice and the charges. Let's spend some time to look at some of the dimensions or some of the elements, because this is a very important piece of a document. We've mentioned that first and foremost, there should be clear indication of the time of the hearing. There should be clear indication of the date, the venue of the hearing. We've spoken about the charges. These charges laid against an accused need to be clearly stipulated precisely and in simple terms without the intention to confuse, because an accused needs to understand these charges clearly. We've also mentioned that there should be rights of an accused clearly stipulated. These rights will empower the accused to know what is allowed and what is not allowed on his or her part. Some of the important rights that need to be included is the right to hear or state your case. The employee or the accused need to know that when he comes to the hearing, he'll be given time and be afforded the opportunity to state his or her case. It's not just going to be the company stating his case, accusing him, finding him guilty, and just issuing a sanction. Number one. Number two, the employee also need to be aware that he's got the right to appoint a representative. And there is clear guidelines from the Labor Relations Act as to who can be a representative for an employee in this case. If he's a member of a trade union, he can allow a shop steward. He can allow a fellow employee to come and represent him amongst other people. It also clearly stipulates who is not allowed. For example, he cannot bring a family member to be a representative. He can also not bring an attorney to be a representative in an internal hearing. So those rights need to be clearly stipulated. The third right, perhaps which is important, is the right to bringing witness or witnesses into a case. Now, obviously, the documents need to be clear so that the employee will be familiar with all these so that he can prepare himself or herself thoroughly. Now, as part of the preparation of the hearing, we do recommend that both parties, the employer as well as an employee, need to prepare some checklists so that they can be able to go through and make sure that they have done everything needed to ensure that their side of the case is thoroughly prepared. The employer on the other side is responsible for leading the preparations by ensuring that the notice, the appointment of a presiding officer, the appointment of the initiator, and serving the notice to an employee has been done accordingly. Issues of investigation, collecting evidence, and other information to back up the case is important, but at the end of the day, if it means you did not notify the employee on time, you didn't afford an employee enough time to prepare, you did not state clearly the right of the employee, you might find yourself in hot water as an employer. On the other side, the employee also need to be familiar with what is needed to prepare for the case. That is why they also need to have their own checklist on their side to understand clearly what are the charges that have been laid against them, to prepare the evidence to defend themselves against the charges that have been laid. This includes, amongst others, bringing witnesses. Because some employees do come to a hearing, but they will claim they didn't know that they can bring a witness. So a checklist needs to be necessary. Now, it is a responsibility largely of a representative to prepare and assist the employee to make sure that he's fully informed about what he needs to be going through as part of the preparation for the hearing. That is why that he's saying, even if it means as an employer or an employee, you might have done this several times, a checklist is still necessary and important. Now, as we go through this, you might have some questions that you'd like to pose. So at this particular point in time, or any other time during the engagement, as we've stated earlier on, feel free to ask questions about what we have covered through the course as we go along. Thank you very much. See you in the next section.